Now, the board requires that the supervisor certify to the board, and again, this is part of 64B19, that the supervisor certify to the board, first, the agreement detailing licensee's obligations and the supervisor's responsibilities. This all has to be in writing. What the supervisor is responsible for, what supervision they will provide, with what frequency, and what it is the licensee is obligated to do. So again, a very careful written description. Also, in writing, an assessment that the licensee is capable of providing safe and competent psychological services. Something indicating that you have decided that that particular psychologist is capable of working with a particular group or a particular type of clients or patients. As noted above, the supervisor is always to maintain professional responsibility for the work of their supervisees, and again, provide 2 hours of clinical supervision weekly, one of which is individual face-to-face. So you have to see the supervisee at least once a week, face-to-face. The other can be a review of their reports, some sort of a training seminar, or some other training opportunity, but individual face-to-face. And that, of course, some people have raised the issue, can that be group supervision as well? The answer is yes. You again have to be kept informed of all professional services performed by the trainee or supervisee, and advise the board of any potential ethical problems. This question that was raised, is this applicable to graduate students in training? I actually raised this with the members of the board, and was promised that there would be a forthcoming response to that. Now, this idea of being kept informed of all professional services, let me return for a moment to the case I gave before, that Illinois case where the supervisor did not know about the client with whom the supervisee was having a sexual relationship. A number of people have raised an issue, and I have to say it is a good issue. I don't really know the answer. But whether or not a carefully crafted, informed consent to supervision would be an effective protection for the supervisor. In other words, have the supervisee essentially sign a contract indicating in advance of supervision that they will share all aspects of a case, all clients that they are seeing. Then if they do not, the supervisor can point to the contract and say that it was basically the supervisee's breach of the contract that led to their not being aware of what went on with certain other patients or clients. It's an open question, but I certainly think it is a good caution. Whether or not it is legally sufficient, I think you would have to check with an attorney on that. But to have an informed consent to supervision would be a very, very important feature. Okay, now that's basically it for the Board of Psychology regulations. There have been a number of other features from the American Psychological Association which have not yet found their way into the actual professional code promulgated by the Board of Psychology yet. I refer specifically to the 2010 change in the APA Ethics Code, which of course had to do with taking a strong stand against psychologists being involved in torture. This, of course, came out of the concerns raised by a number of psychologists, notably the group called Psychologists for Social Responsibility, in which there were assertions that psychologists were participating in aiding and abetting, using their psychological knowledge to assist torture at the Guantanamo Bay facility. APA took a very strong stand against this, actually amending the APA Ethics Code to say that while in general a psychologist can follow a lawful court order even when it conflicts with other parts of the ethics code, such as in releasing certain records, this does not apply when there is a violation of basic human rights. That becomes an exception, and that one does not have to follow the law if it involves a violation of basic human rights. That particular part, that it's basically an amendment to the 2002 Ethics Code of the American Psychological Association, which was made in 2010. That particular feature has not yet found its way into the regulations of the State Board of Psychology. I expect that it will, but it has not as of yet. Now, let us talk a little bit about some new APA documents. This is the first thing I'm going to be talking about are the new APA guidelines for child custody evaluations. These came out in December of 2010. There are a number of changes from the prior version, which came out in 1994. The 1994 version had been incorporated directly into Florida law in section 64B19-18.007. The current version has not yet been incorporated into Florida law. Most likely it will be, and for that reason I think we need to be aware of it. The first thing to be noted as a change from the prior version, and I certainly do recommend that you take a look at both versions of the APA child custody guidelines, is that there is now a clear distinction between forensic evaluations and advice given during the course of psychotherapy. This is important because a number of psychologists who get involved in sticky family issues when they are treating families that are going through contentious divorces and separations and arguments about custody of children, will identify themselves as exclusively providing therapeutic services. Yet during the course of therapy, inevitably some advice is given regarding the placements, how long a child should be in a particular environment, whether a particular environment is helpful to the child or whether it hurts the child, and that these are given within the course of therapy, clearly as a function of the psychotherapy. Inevitably, what happens is, in order to make their case stronger, attorneys for both sides, or for the one side where they feel that the opinion is of assistance to them, will call that treating psychologist into court. Sometimes the treating psychologist does not make a clear enough statement that their opinion is based purely on the psychotherapy, that they have not done a formal child custody evaluation, that what they're expressing is limited by virtue of the setting within which it occurred. Nevertheless, these psychologists have been sanctioned for making child custody recommendations without conducting a full child custody assessment. And in fact, a number of these psychologists have been at the receiving end of Board of Psychology and in fact APA ethics violations, because it is contended that they made custody recommendations without having done an adequate custody evaluation. So this new set of guidelines makes a clear distinction and can be relied upon by psychologists who are giving advice during the course of psychotherapy but not doing formal custody evaluations. Even if they get drawn in through no fault of their own into some sort of a testimony regarding custody. I recently reviewed a case, in fact, where the psychologist who was providing therapeutic services, in fact, refused to testify, stated that she would testify only if the court ordered her to do so. She stated that she was the therapist, not a custody evaluator, and the court, in fact, did order her to testify, despite her qualifying her statements, indicating that she was a therapist, that she was not doing a custody evaluation. The dissatisfied party went ahead and filed ethics charges with the State Board of Psychology. Had these guidelines been in effect at that time, hopefully it would have prevented that kind of situation from occurring. We don't know, of course, whether it would, but it would appear that this would provide the structure, the framework, to make that a legitimate undertaking that is discussing what is best for the child from a therapeutic point of view, without it then being called a custody evaluation or a custody recommendation. The second thing to keep in mind, that other kinds of evaluation, such as evaluations for the purposes of child protection, that is, an emergency withdrawal of a child from a particular setting because there is a suspicion of abuse, these are not covered by these guidelines. This again is a distinction from the prior set of guidelines, the 1994 guidelines, in which such situations were covered. The new guidelines continue to use the word custody, despite the fact that the preferred term these days in contemporary psychology is parenting plans or shared responsibility. It continues to use these words because legal authorities still use the term custody more widely. In other words, the term parenting plans and shared responsibility is much more common among psychologists, but among courts and among lawyers, they still use the word custody, and so that's the way that these particular guidelines are phrased. The guidelines have a broader use of the term parent. It used to be that, of course, parent meant a man and a woman who were legally married. The current broader use of the term includes couples of the same sex, unmarried couples, and other situations where there may be people raising a child. So the term parent does not necessarily mean biological parent anymore. The role of the court in defining what the concept best interests of the child is much more carefully specified when the parents cannot agree. And of course, that is the only circumstance under which a case would generally come in front of the court. We should bear in mind that it is the minority of cases that actually become hotly contested custody evaluations. Most cases are relatively amicably and mutually agreed upon and don't require major protracted custody evaluations and custody hearings. But in that limited number, the role of the courts is specified in these guidelines in defining what the best interests of the child are.